You are thinking about filing bankruptcy alone without your partner filing. You have actually possibly questioned just how will your bankruptcy affect your spouse. The bright side is that in the vast bulk of situations, your bankruptcy will have no influence on your spouse. In most cases, there will be no legal effects when only one spouse files for bankruptcy. The purpose of this Brandon's blog is to discuss the financial and legal implications of bankruptcy. No doubt the stress and strain of one spouse's debt load will place a strain on the household and the partner. Providing marriage advice is not my specialty, but insolvency is. How will my bankruptcy filing impact my spouse's credit? Each individual has a separate credit rating and a unique credit report. When married, people's credit scores and credit reports are not blended. There is no credit record that combines reports of married or common law partners. That merely does not exist. If you make your payments on that separate credit card and they're on time, or even continually late, it does not aid or harm your partner's credit rating. Different financial obligations are never ever reported on anybody else's credit report and do not impact their credit score. So when people wed, their credit ratings are not combined or averaged in any way. They stay separate. For example, if you open up a credit card in your own name and do not include your partner as a supplementary card holder, the credit history and debt for that credit card will never appear on your partner's credit history record. Marriage or a common law relationship, this does not alter the fact that credit scores and reports are not combined in any way. For that same reason, if you file bankruptcy on the separate debt, it is also not recorded on your partner's credit report and will certainly not influence their credit score. That's the tri-joint debt, which is where both you and your partner are responsible for that debt. If just one partner files for bankruptcy, there is no impact on the non-filing partner's credit rating. However, the non-filing spouse remains responsible to pay that debt. If the non-filing spouse does not do so, then it will affect that spouse's credit rating and score. Not because their spouse filed for bankruptcy, but because they are fully responsible for a joint debt. That is the trick. Can one spouse file for bankruptcy if you share property? The second reason why one spouse's bankruptcy will generally not impact a non-filing spouse is that spouses are allowed to own property in their separate names. Added to this, the vast majority of debts such as credit cards, car loans and mortgages are created by contract. This means that only the person who agreed to be liable on the debt can be affected by it. Except in rare instances, one spouse is not required to pay the debts that are solely those of the other, either through their wages or their assets. If you have joint property, your non-filing spouse's portion of that property cannot be taken to pay your debts. Your licensed insolvency trustee, formerly called a trustee in bankruptcy, trustee, only holds the bankrupt person's interest in the property. While joint property can sometimes be sold, the non-filing spouse's portion of that property must be returned to the non-filing spouse. It is never used to pay the debts of the filing spouse. The non-bankrupt spouse would, of course, be the natural purchaser of the bankrupt spouse's interest in such joint property. Can one spouse file for bankruptcy if you share debts? So you open a new credit card in your name and do not get a supplementary card for your spouse. In that situation, your partner does not get a card for your account. Therefore, your partner also did not consent to be collectively responsible with you on that credit card. If you fail to make a payment on that bank card, they cannot sue your spouse. If they can't sue your partner, they cannot get a judgment against him or her. If they can't get judgment, then they cannot garnish your partner's wages. They cannot take your partner's different bank account or different assets. The credit card can just go after you, the individual that consented to be liable for it. This does not change because of a marital or common law relationship. Therefore, if you file for personal bankruptcy, your non-filing spouse's property and income cannot be taken by either the court or your trustee. If a creditor reports a joint debt in the filing partner's bankruptcy on that person's credit record, that does not influence the non-filing partner's credit history. However, for any joint debt, or a debt of the filing spouse that is guaranteed by the non-filing spouse, that is a different story. The non-filing spouse must live up to his or her obligations, which includes the responsibility for the joint or guaranteed debt after the partner files for bankruptcy. If not, then the creditor definitely has remedies against the non-filing spouse. Not because they are the non-filing spouse, but because they are equally liable for the debt. However, if a creditor incorrectly reports the joint debt as being included in a personal bankruptcy on the non-filing partner's credit report, I do suggest that the non-filing spouse write to the credit reporting agencies to get it corrected. The reason for this is because the non-filing spouse is not involved in a bankruptcy. Can my spouse and I file for joint bankruptcy? Section 155, F, of the Bankruptcy and Insolvency Act, RSC, 1985, c. B3, BIA, states. In such circumstances as are specified in directives of the superintendent, the estates of individuals who, because of their relationship, could reasonably be dealt with as one estate may be dealt with as one estate. Section 66.121.1 of the BIA states. Two or more consumer proposals may, in such circumstances as are specified in directives of the superintendent, be dealt with as one consumer proposal where they could reasonably be dealt with together because of the financial relationship of the consumer debtors involved. So, it is possible for spouses to file a joint consumer proposal to avoid bankruptcy, or a joint assignment in bankruptcy. What is necessary is that the majority of their debts are joint. Each situation will be different. Many times I have advised couples that they should file jointly. This is most useful where if only one spouse files either a consumer proposal or bankruptcy, the other spouse will not be able on their own to pay the joint debts. A joint filing will be more streamlined and less costly than if each spouse filed separately. When considering a joint versus single filing, follow the financial advice the trustee provides. I once had a situation where the husband came to see me. He needed to file, but so did his wife. The reason was because of the predominance of joint debts. I advised that it would be best for the husband and wife to come see me together, so that I could explain the benefits of a joint consumer proposal filing to both of them. The husband, thinking that he was protecting his wife, was adamant that only he would file. Against my recommendation, he insisted on filing alone. We filed his consumer proposal. As expected, the creditors where the debts were joint, starting making demand on the wife. She was unable to pay up, so, she too had to file a consumer proposal with me. The unfortunate part was that the sum of the amounts that needed to be paid for a successful consumer proposal was greater than if they had filed jointly. So, as a family household, it cost them more than it would have if they filed jointly. Both the husband and wife each made all the payments required under their respective accepted consumer proposals. It is just too bad that the total paid was more than if they had filed jointly. Summary. Now what we have discussed are simply generalities. There are situations that do not fit neatly within these rules, but that's why you need an experienced LIT to help review your situation. Do you have way too much debt? Prior to you getting to the phase where you can't make ends meet and your credit report looks awful, reach out to a licensed insolvency trustee, previously called a bankruptcy trustee. In fact, if you understand that you can't pay your financial debts, contact us. We understand the pain and stress excessive financial debt can trigger. We can aid you to get rid of that discomfort as well as address your financial problems, offering prompt action and the ideal plan. Call Ira Smith Trustee and Receiver Incorporated today. Make an appointment with one of the Ira Smith team for a free, no-obligation consultation and you can be on your way to enjoying a carefree life starting now. Give us a call today so that we can help you get back to stress and pain-free life, starting now.
I hope you enjoyed the video. The Ira Smith team is available to help you at any time. We offer sound advice and a solid plan for starting now, so that you'll be well on your way to a debt-free life in no time. For more information on a no-cost basis, please visit our website or call us. Our website and telephone details are coming right up now.